I know previously it is in the list before the holidays. It is not listed to them. Criminal appeal matter, tied up matter.
Give it.
Supplementary list item number 1.
C2B भी अच्छा है. So since the offenses involved in the case, no, notice has to go.
Notice has to.
Extra copy of the bail application will called on the land council for the land council for the state submits that he has received the case diary. List this matter in the recommencing from 20th of January 2025. Confirmation letter regarding response will be obtained in the meantime.
Item number 2.
You have received the case diary.
Yes.
So these offenses also require, in view of the decision of the Supreme Court,
Notice.
that it requires notice also. So same order, you serve an extra copy, and he has already received the case diary. Same date, we commencing from 20th of January 2025.
Item 3.
CD is requirement.
CD is not there and serve an extra copy, let the notice go. Okay. Same order for them. And here case diary is not available. And you have to obtain that CD
Yes.
164 medical exemption report. Okay. Let him bring that. Yeah.
Item 4.
Cheating and perjury. Other
Amount is, I think it is.
that CD will be required because the systematic crime has been committed by the person.
You have to require also
CD.
instruction about the criminal antecedent.
Yes,
It's a cheating amount appears to be 6.28 crores.
Suspend is initially, but it will be with the other persons might have been they thank because the economic offense constitute a class apart from other things as per the Supreme Court judgment.
All right, land council, CD, criminal antecedent, and matter is adjourned to 20th of January 2025.
Item 5.
In terms of 6 samples, 336 plus 3, 336 plus 4, 356 plus 2, 351 plus 2 of BNS 5, where is section 66E, 67 and 67A of IPS. The allegation of the informant is that she has formed the relation with the present petitioner through Instagram, and after their conversation and for the purpose of marriage, they do the video calls. During video calls, the petitioner has taken some nude photographs and viral it when the informant knows about that the petitioner is a married person. Petitioner is controversies based also given the
Charge sheet submitted.
or
The CD
That is the FIR has been lost by the victim herself.
victim self.
age of 22 years.
मोर सह बंधुता बढ़ाइला 500 करी विवाह करी प्रतिश्रुति
Instagram video.
There is no physical relationship. It's just
only the nude photographs
they
obtained
were
are
chatting
chatting. Yes.
as it appears, and video calling also, and in that video calling, uh, these nude photographs were taken.
That uploaded in a fake ID.
Polite, heard the learned counsel for the petitioner, learned counsel for the state, considering the submission made by the learned counsel for the petitioner that the petitioner is in judicial custody since 23/10/2024. Investigation has made substantial progress. And keeping in view the age of the victim and the first information report, and after hearing the land counsel for the state, I am inclined to release the petitioner on bail subject to condition that the victim shall not try to come in contact with the petitioner shall not try to come in contact with the victim in any manner, and shall not try to tamper with the evidence and appear before the learned trial court on each date when the case will be posted for trial. He shall not indulge in any criminal activities. Violation of any terms and conditions shall entail cancellation of bail allowed.
Okay.
Item 6.
Here is the 6 of 103 BNS. It is required.
Corresponding to 302 manner, the similar matrimonial arising out of the same case, that is PLPL number 12577.
Just a minute.
577 of 24 has been adjourned to 22/1/2025.
Mr. Arijit Mishra and counsel for the petitioner submits that who accused has approached this court by filing in a bail application which has been registered as PLPL number 12577 of 2024, and the said case is posted to 22/1/2025, and case diary has already been called for in the said case. This matter along with PLPL number 12577 of 2024 before the assigned bench. You noted down the number.
Yes, yes. 127.
Item 7.
376 2N.
Achha.
376 2L manner and 506. The victim is aged about 20 years manner, and charge sheet has already been submitted.
You have not received the.
I have got the copy of the.
Serve and let the notice go, because now the decision has come that in such type of cases the opportunity should be given.
POCSO is not there.
POCSO is not there.
No.
In for ICC, it is October 17, 10, 24. The informant was parking his stroller near a better both person including the petitioner. After that, the informant and the helper and Chicago is there. Using the amount 1,08,000. Nothing has been reported from the petitioner.
But it reveals that you are involved in 5 cases under Chandrasekharpur police station, 1 case under Mayapalli police station, 1 under Badamba, 3 cases are under Tigriya police station, and mention that you are in habitual. So file a comprehensive affidavit You have obtained that
No, no.
case diary. The Learned Counsel for the state seeks some time to produce the case diary. And from the rejection order, he pointed out that there are several cases instituted against the petitioner in different police stations, and that the petitioner is a habitual offender. Learned Counsel for the petitioner seeks some time to obtain instruction regarding the status of those cases and file a comprehensive affidavit. Serving a copy and the Land Council for the state put up this matter in the week commencing from 20th January 2025. Yes,
Item 9,
Offense under section 20B2B. 5 kilo ganja has been seized from the petition.
is it mentioned in that rejection order?
Yes, yes.
And what is the date of custody?
26/11/20.
All right, considering the submission made by the Land Council for the petitioner, that the petitioner is in judicial custody since 26/11/2024, and the contraband ganja stated to have been seized from the possession of the petitioner is 5 kg, which is lesser than commercial quantity, and therefore bar under section 37 of the NDPS Act is not applicable, and that investigation has made substantial progress. After hearing the Land Council for the state, I'm inclined to release the petitioner on bail allowed.
item 10,
Matter custody since 30/11/2024. Offense under section 331(4) and 305 of the NDPS Act. Corresponding is 457 and another is 379.
457, 379.
Allegation of a theft of some gold ornaments, which are subsequently recovered from the premises.
What about your criminal antecedents?
So far as fictional one is concerned, we have got one antecedent, two has got no antecedent.
You are in custody since
30/11/2024.
are the Land Council for the petitioner, Land Council for the state, considering the submission made by the Land Council for the petitioners that the petitioners are in judicial custody since 30/11/2024, and the offences are traveled by magistrate, and stolen gold ornaments have already been recovered. And after hearing the Land Council for the state, who submitted that the petitioner number 1 has got one criminal antecedent, I'm inclined to release the petitioners on bail allowed.
There are
Item 11.
condition.
It will not indulge in criminal activity. That's it. That's it.
item 11,
May I please? And the petitioner is in custody since 24/11/2020 for offense 417, 420, 468, 471. My lord, it is alleged that the petitioner has taken some money from the instrument to write him a job, my lord. Railway department.
How much amount you have taken?
My lord, as per the FIR, my lord, 1,50,000.
3,80,000.
You are in-
3,80,000 has been cheated. Plus CD is required because this type of offense, as your lordship knows, that to obtain whether he has committed any other offense of this nature or not.
in respect of other persons.
Other persons.
Okay, all right, you get the instruction.
Yes,
The
sir.
Land and Council for the state seeks some time to produce the case diary, and particularly about the criminal antecedent, if any, against the petitioner, and whether during course of investigation it has been brought on record that apart from alleged cheating, the informant, in this case, the petitioner, also involved in similar activities or not. This matter in the week commencing from 20th of January 2025. Yes,
item 12,
At 20 6 kg. Conscious for this.
22 Bs of NDPS Act 6 kg 110.
your custody date is
Date is 6 December 2020.
are the Land and Council for the 6/12/2024, 6 kg 110 allowed.
item 13,
276(3) and serving a copy marriage.
Extra copy we served, served in court today. And have you obtained the case diary?
No, no.
Case diary is not there. CD 164 medical
164 I
exemption.
find.
and confirmation letter regarding service of notice. Matter to be listed will commencing from 20th of January 2025. Yes.
Item 14.
May I have? If you know, there is a receiver of the program for the final. In further business paid 2024 on transactional statement of the
What is the date of custody?
8/12/2020. And
Or the learned counsel for the petitioner and counsel for the state. Considering the submission made by the learned counsel for the petition, that the petitioner is in judicial custody since 8/12/2024. And the allegation against him is that he is the receiver of stolen property, and the offense alleged against the petitioner traveled by magistrate, and after hearing the land counsel for the state.
Habitual offender, habitually receiving the property, the condition may be improved.
Involved in other cases and inclined to release the petitioner on bail subject to condition that he shall appear before the IAC of so police station once in a week for a period of 3 months. Hello? Yes. Sir.
Item 15.
may I please alert. Question number 13/12/2024. Offense under section 52A, 52C, 55. Case of the Orissa Excise Act, Redo section 274, 275, 5 of the BNS Act.
274.
That is what is that is available in national law.
Just a minute.
The entire allegation of there is a strike of the villagers in the demanding the brutal activities of the police agency. Thereafter, 21 FIR has been registered by the police agency. So now, before a lawsuit, then the bail application there, relating to 10 FIRs out of 10 incidents. The lawsuit kindly peruse the FIR. There is no time. Page 10 of every bail application, ସବୁ ଯାକ ଗୋଟେ type ର ଲେଖା ହେଇଛି, ଖାଲି quantity ଟା ଅଲଗା କରାହେଇଛି ଏବଂ time ବି କୋଉଠି ପଡେନି ଯେ କେତେବେଳେ ସେ ରେଟ୍ କରିବା ପାଇଁ ଯାଇଛି। ଆଉ ସବୁଠି କହୁଛନ୍ତି ଯେ 13/12/24 ରେ as per the order of Superintendent of Police ଗଞ୍ଜାମ ସେମାନେ ଯାଇଥିଲେ ରେଟ୍ କରିବା ପାଇଁ। ସମୟ କୋଉଠି ନାହିଁ ଆଉ stereotype ର FIR ସବୁ ଯାକ ସବୁଥିରେ ଖାଲି quantity change ହେଇଛି different person। ତ ଯୋଉ 2-3 villages nearby villages 21ଟା FIR ହେଇଛି।
No, this Yogi Sabar,
Again,
he is involved in all these cases.
no manner.
No?
In all the different cases, different person. ଗୋଟେ ଗୋଟେ ଲୋକଙ୍କ ନାଁରେ 21ଟା କେସ୍ କରିଛନ୍ତି। କାହିଁକି ସେମାନେ ପୋଲିସ ବିରୁଦ୍ଧରେ ଷ୍ଟ୍ରାଇକ୍ କରୁଥିଲେ ବୋଲି। ସବୁ ଯାକ ମିଛ କେସ୍ ତାଠାରୁ କିଛି ସିରିୟସ୍।
No, that means you have got 21 criminal antecedents.
No manner.
Then you said that 21
ଜଣଙ୍କ ନାଁରେ ନୁହଁ sir।
or 22 altogether.
Person ଅଲଗା ଅଲଗା ଲୋକଙ୍କ ନାଁରେ
Altogether 21 cases were instituted
ଆଜ୍ଞା ଯୋଉମାନେ ସବୁ
against different persons, not that same person.
ଆଉ FIR ଷ୍ଟୋରିଟା ପୁରା ସବୁ ଯାକ ଗୋଟେ ପ୍ରକାର, ଖାଲି କୋଉଠି ଟାଇମ୍ ପଡିନି କେତେବେଳେ କୋଉଠି ରେଡ୍ କଲେ, ସେମ୍ ଇନଭେଷ୍ଟିଗେଟିଂ ଅଫିସର ସେମ୍, ଇନଫର୍ମାଣ୍ଟ ସେମ୍, ଆଉ ଖାଲି କ୍ୱାଣ୍ଟିଟି ଅଲଗା ଅଲଗା କରିଛନ୍ତି।
700 ଲିଟର ପୋତ 550।
This is not magistrate tribunal. 274, 275. In Odisha amendment, it has been made
ସେଥିରେ ଥିଲା ଏଥିରେ ବର୍ତ୍ତମାନ କିଛି ହେଇନି।
same Asiole
ଆଜ୍ଞା
274. It is
272
Hon'Ble ବୋଲି ଥିଲା ଓଡ଼ିଶା ଆମେଣ୍ଡମେଣ୍ଟ, କିନ୍ତୁ BNS ରେ କିଛି ହେଇନି।
no BNS ରେ ଦେଖଉଛି ବର୍ତ୍ତମାନ 274, 275 ଗୁଡା କହୁଛି ନାଇଁ magistrate tribunal ଦେଖଉଛି 274.
Any magistrate.
punishment 6 months, 5,000 fine.
ପୂର୍ବ offence ଟା କେତେ ଥିଲା ସେଇ same ଥିଲା ନା 270
72, 73 ଥିଲା।
ଆଚ୍ଛା
IPC 272 and 277.
Have been arrested in one. In their arrest, ସମସ୍ତ ନାଁରେ କେସ୍ ହେଇଛି ସମସ୍ତେ ସେଇଦିନ ହିଁ ଆରେଷ୍ଟ ହେଇଛନ୍ତି।
So what is your submission when counsel has mentioned that there is no criminal antecedent will be a submission is and
It's a 9 subject to a law.
state has also not produced any material in the rejection order there is nothing rejection ହେଇଛି on the ground of huge quantity of
Yes.
liquor seized and so on so you are a local man
Minors. ସବୁ ଗୋଟେ
or the land counsel for the petitioner land
The
counsel for
adulteration and the impact of society. That's that.
the learning counsel for the petitioner submitted that the petitioner is in judicial custody since 13/12/2024 and is a permanent resident of village Badapali under High Court Police Station in the district of Ganjam. And the investigation has made substantial progress. And since the villagers, what they did, they were, according to you, they were complaining against the
Yes, sir. Police ଜଣକୁ illegally arrest କରିବା ପାଇଁ ଆସିଥିଲା ତା ବିରୁଦ୍ଧରେ ଗାଁ ଲୋକ ଅପୋଜ କଲେ ଗାଁ ଲୋକ ଭିତରେ ଗୋଟେ କେସ୍ ହେଇଥିଲା ତାପରେ ଏଣ୍ଟାୟାର 2-3ଟା ଭିଲେଜ ର ଲୋକ ଯାଇକି ପୋଲିସ ଷ୍ଟେସନ ଷ୍ଟ୍ରାଇକ୍ କରିଥିଲେ ତାପରେ ଏଇ କେସ୍ ଗୋଟେ ଦିନରେ 21ଟା କେସ୍ ହେଇଛି ଇନଫ୍ୟାକ୍ଟ ଏମାନଙ୍କୁ ସବୁ ଥାନାରେ ରଖିକି ଗୋଟେ କେସ୍ ଦେଇକି ଫରାର କରିଛନ୍ତି।
That part has not come to the
ଟାଇମ ବି କୋଉଠି ଲେଖା ହେଇନି ଯେ କୋଉ ଟାଇମରେ କଣ ହେଇଛି।
just a minute. It's submitted. That since there was protest against the outrageous activities of the police, false cases against the villagers were instituted and therefore the bail application may be favorably considered. Learning counsel for the state, on the other hand, opposed the prayer for bail and submitted that huge quantity of liquor has been seized from the possession of the petitioner. And the investigation is at nascent stage. And therefore, petitioner should not be released on bail. Considering the submission made by the learning counsel for the respective parties, the nature of accusation against the petitioner, period of detention of the petitioner in judicial custody, and inclined to release the petitioner on bail subject to condition that it shall appear before the inspector in charge of High Court Police Station once in a week on every Sunday between 10 to 4, and he shall not indulge in any criminal activities. Appear before the on each date to be the a case would be posted. Violation of any terms and conditions shall entail cancellation of bail.
Item 16.
No, it's a different person.
Different person, all are different.
And this man is also a local man.
Yes, sir.
And custody is same.
Same date.
All right, allowed. 18 एगुड़ा सब ସେଇଆ ଦେଖିଦେବେ ଖାଲି ହଁ 18 19 20 21 23 26 30 yes next allowed
Item 17.
Informant is the wife of the petitioner. Yes, what she has alleged against you.
Allegation is that the petitioner came to her house and assaulted her and her daughters by means of various kind of influences.
पढ़िले पढ़ले ये जो एफआईआर का पढ़िले Its IPC offences are
IPC offenses
354. Yeah, then
323,
323,
341,
341.
307,
Yes,
294, 30.
294, 34. 307 ला कौन material अच्छी?
My lord, material is
कोट लिखा है इसको पढ़ो.
पानी ग्लास रे मो मुंडो रा आँखि को मार
पानी ग्लास रे मुंडो को पिटी देला.
गोटा रे मो मुंडो को मारला.
What this man is doing now? What is his avocation? 53 वर्ष कौन करे?
some small business.
GD report indicates minor injuries, of course. That is mentioned in
Rejection order.
rejection order. The injury reports of the informant as well as daughter Sasmita Parmishta Mahanti reveals that they sustained some minor injuries on their person. Acha, you had an earlier case also. Your wife also instituted another case in which you have been released on bail, as it appears from the rejection order.
You want to be behind the bars in another
मधुपर्णा केस के सुन 213
or the learned counsel for the petitioner, learned counsel for the state, considering the submission made by the learned counsel for the petitioner, that the petitioner is the husband of the informant and he is in judicial custody since 8/11. No, it is mentioned that 10/11/2024, and on account of matrimonial dispute between the parties, the case has been foisted, and the injury sustained by the informant as well as the daughter of the petitioner and the informant are minor in nature. And after considering the submission made by the land council for the state, stated that on account of similar matrimonial dispute, another case was instituted by the informant against the petitioner, in which he was released on bail in Madhupatana PS case number 213, dated 4/7/2024, on condition that he shall not commit similar offences. I am inclined to release the petitioner on bail subject to conditions that he shall not indulge in any criminal activities and and or try to tamper with the evidence, and he shall appear before the inspector in charge of which police station? Chalaganj police station, once in a week on every Sunday in between 10 to 4. Madhupatana, IAC Madhupatana police station. And violation of any terms and conditions shall entail cancellation of bail. The inspector in charge of Madhupatana police station shall send a lady police officer in the rank of SI to the house of the petitioner to ascertain the to meet the informant as well as her daughters to ascertain about their condition. And the said report be placed at least twice a month, and the said report be placed before the learned JMFC 4 cognizance taking bracket reformer. If any adverse report is submitted by the lady police officer, it is open to the concerned magistrate to take steps for cancellation of bail in accordance with law. Yes, allowed.
Item 22.
Case 11/24 minutes, but the offense number is 305, 331/4 of BNC, corresponding to 384/57. The petitioner will not lend any manner on the basis of statement of the confession statement of the working. Police and the petitioner arranged an act. The police have already well made by the order of this honorable court and item number 10.
Heard the learned counsel for the petitioner and counsel for the state. Considering the submission made by the land council for the petitioner, where the petitioner is in judicial custody since 30/11/2024, and his implication in the case is based on confessional statement of accused, was being released on bail in DLAPL number 13032 of 2024. And the offences are travelled by magistrate, and after hearing the learned counsel for the state and inclined to release the petitioner on bail. ତା ଦେହରେ ଯାହା condition ଥିବ ସେ item number 10 ରେ ସେଇ condition ରଖିଦେବି ହେଲା yes
Item 24.
is it mentioned in the rejection order where is that
25 times.
and what will be date of custody
September 8 to that 30.
or the land and council for the petitioner land council state considering the submission made by the land council for the petitioner that the petitioner is in judicial custody since 23/11/2024 and the quantity of contraband ganja stated to have been seized from the possession of the petitioner is 10 kg, which is lesser than commercial quantity, and therefore bar under section 37 of the NDPS Act is not applicable. And after hearing the learning council for the state, I'm inclined to release the petitioner on bail allowed.
Item 25.
$85,
490.
498,
492
ତାପରେ ଆଉ ଗୋଟେ କଣ
304
ଓ 304 ବି ଅଛି case diary ଅଛି
no madam
I have filed the postmortem.
no letting from the land and council for the state submits seek some time to obtain the case diary. Is this matter in the week commencing from 20th of January 2025? Yes.
Item 27.
What is this offense, Mr. Pradhan? 309.
309 PNS and 392
What is that corresponding?
392 92 I think.
Nine four. May extend to 10 years. What is the allegation here? What is the subject matter of case? 4 unknown persons came in a Pulsar motorcycle bearing registration number so-and-so, scooty so-and-so, by threatening snatch away mobile phone. The mobile phone has been recovered also. What is the date of custody?
Date of custody
10/11/2024. They were nabbed on Badal and Niraka were nabbed by the police and okay. Heard the land and council for the petitioner land council for the state, considering the submission made by the land council that the petitioners are in judicial custody since 10/11/2024. The offences are travelled by magistrate and the stolen mobile phone and the subject matter of robbery as the mobile phone which has already been seized. And after hearing the land council for the state, I am inclined to release the petitioner on bail allowed.
Item 28.
Wait, offense from the
399/402 the petitioner has no criminal antecedent but the modus operandi is they have committed they have targeted the drivers and snatching away their mobile phone. They confess that They have committed, they have snatched away 300 to 500 mobile from different drivers, and all total 80 numbers of mobile phone recovered from the possession of the other co-accused person. And the present petitioner was using his own car in committing all this offense. But petitioner has no criminal incident.
Able to learning.
Custody 11 1 11 24.
Or the learning counsel for the petition, learning counsel for the state, considering the submission made by the learning counsel for the petitioner. But learning counsel, why have you not approved the sessions court?
Rejection order passed by the Lord and second.
उत्तर लिखा है कि SDGM फाइल
से पास्ट सेटा फास्ट रिजेक्ट करथिले तापर पेज 22 रे
Rejection ଅଛି.
rejection
considering the submission made by the land council for the petitioner, that the petitioner is in judicial custody since 1/12/2024, and there is no criminal antecedent against the petitioner.
Arrested at the spot.
And no incriminating article has been seized also from the position of the petitioner. And after hearing the Land Council for the state who submitted that the petitioner was apprehended at the spot, and from the accused persons, huge number of stolen mobile phones were seized. I'm inclined to release the petitioner on bail subject to condition. He shall appear before the IAC of Talcher Police Station once in between 3 to 4, and shall not indulge in any criminal activities allowed.
Item 30.
Item 30. Use a liter consummate liquor, no sales.
What is your custody date?
5/12.
6/12. Are the Land Council for the petitioner, Land Council for the state, considering the submission made by the Land Council for the petitioner, that the petitioner is in judicial custody since 6/12/2020, and the offense is triable by magistrate, and after hearing the Land Council for the state, and is inclined to release petitioner on bail allowed.
31, 32.
Item 31.
Please, your lordship. Lord, I am appearing virtually. Here I am in custody since 7th of September 2024.
What are these offenses, Mr. Panda?
My lord, it's under the BNS. The offenses are 109.
307.
The main offense is 307.
Yes, 109.
Insult injury.
Okay.
Luckily saved.
Lucky, my lord.
ହାତରେ ବାଜିନି କାନ୍ଧରେ ବାଜିଛି.
Injury is on the scapula.
କଣ ହେଲା ପୁଣି ତାର injured ର
Time
କଣ?
declaration was
Injured has been, my lord, discharged from hospital. So that's why charge sheet has been submitted on 307. And this arises, my lord, out of a love triangle relationship between the wife of the daughter-in-law of the informant and the petitioner.
By the Land Council for the petitioner, that the petitioner is in judicial custody since 7/9/2024, and the injured has already been discharged from the hospital and is quite hale and hearty, and charge sheet has already been submitted. And after hearing the Land Council for the state, I am inclined to release the petitioner on bail subject to condition that he shall appear before the Land trial court on each basis and shall not try to tamper with the evidence. Violation of any terms and conditions shall entail cancellation of bail allowed.
Obliged.
Item 32.
2,970 liters of ID liquor, 2911 custody. CA not verified.
Petition number 1 is 1C. Petition number 2 is not.
Are the Land Council for the petitioner and council for the state, considering the submission made by the Land Council for the petitioners, that the petitioners are in judicial custody since 29/7/2024, and offense is triable by magistrate, And after hearing the land counsel for the state submitted that the petitioner number one has got one criminal antecedent. And petitioner number two has got no criminal antecedent. And that huge quantity of liquor has been seized by the excise officials and inclined to release the petitioner on bail subject to condition shall appear before the which is the excise IIC so and so EI and EB hella cutter for a period of 3 months on Monday Monday in between so and so. Yes, allowed.
Item 33.
376. 372 notice required.
Extra copy to be served, notice to be issued, matter to be listed on 20th of January 2025, CD 164, medical exemption with confirmation letter regarding service of notice. Yes.
Item 35.
750 liters liquor, 1000 liter pocha. Custody 1312.
Are the land counsel for the petition, land counsel for the state, considering the submission made by the land counsel for the petitioner, that the petitioner, who is a lady, is in judicial custody since 13/12/2024, and investigation has made substantial progress, and there is no criminal antecedent against the petitioner. And after hearing the land counsel for the state who submitted that huge quantity of ID liquor was seized from the possession of the petitioner, and keeping in view the proviso to section 437(1) CRPC Jota BNS, and inclined to release the petitioner on bail and out.
Item 36.
But during the second journey, the petitioners decided the matter directing to surrender to the court. The meantime, that it has already been submitted and there is a cloud of compromise.
File in the bail application, you file that affidavit. It appears that the earlier the petitioner approached this court for anticipatory bail, which was disposed in ABLAPL number 2497 of 2021, which was disposed of on 15/2/2022, and the petitioner was asked to surrender in the court below and move application for bail. Stop. The petitioner has not complied with the state complied with the order, said order. However, it is submitted by the land counsel for the petitioner that in the meantime, on completion of investigation, charge sheet has been submitted and the matter has been amicably settled between the parties.
The case has been transferred to SDJM court to JMFC Conasam.
And the case is now pending before the land and JMFC Kanas in GR case number 589 of 2021. Considering the submission, land counsel for the state opposed the prayer for bail.
Injury grievous in nature. Injury grievous in nature.
The injuries are grievous in nature. Considering the submission made by the land and counsel for the respective parties, while not inclining to release the petitioner on bail, usual direction surrender. In the first hour, it is to be disposed of by JMFC Kanas. A record is to be transmitted to the Court of Session without awaiting for the formal order. If the petitioner gives files a memo that he will move the application for bail before the Court of Session on the same day. And in case so and so is moved, same shall be disposed of expeditiously, preferably on the same day. Yes.
37 also same.
Next item also same.
Only disposed of different.
Item 38.
Very
But
available.
the filter, no, it is not available.
और अपन इतने धरचुन से
No, it is.
अच्छा so Mr. Patnaik, you are appearing for
Was
the
the informant, my
so you have filed your power
lord.
like Mr. Abhijit Patnaik and his associates have already entered appearance on behalf of the informant by filing VNAMA. VNAMA is accepted. The name of Mr. Patnaik and his associates can be reflected in the causative transcript. Learned counsel for the state submits that he has not received the case diary. With a copy of the bail application be served on Mr. Patnaik.
Already.
By Monday, put up this matter in the week commencing from 20th of January 2025. Yes.
Small prayer. I pray to call for the status report of the trial in the meantime.
Acha. Let us start the status report be called for from the London trial. File be placed before the London registered judicial usual order.
Would like.
Yes.
Item 39,
120B307 Supra IPC, reading the section 3 and 5 of US Act. Whether the anticipated bail application was allowed, that is annexed to running page 26 also. The injury is simple in nature.
The absconding acid and the absconding 307 and the 6 of the.
No, you as it appears you are granted anticipatory bail. So why didn't you comply the order? There was a direction
There was
that
direction to the arresting officer.
yes, then what has happened?
It was kept with the arresting, but the same had not been sent to the London trial court and the
What?
well, the
No, this your anticipate this 2596 of 2017.
Lordship.
It's a regular bail application by which petitioner? By which accused?
By same
Huh?
same accused she was not
2596 of
Proof
2000.
in respect of titullarship.
That you said. Okay. So this case is of the year 2017
Lordship.
and you are an absconder.
Lordship. Then 2020, the anticipated bail application of the same person was allowed.
Which case?
Annexed to running page 26, Lordship. I have annexed the anticipated.
When the charge sheet was submitted,
Charge sheet submitted, Lordship.
have you got a copy of the charge sheet?
I have annexed all the.
You have annexed it.
Lordship. Annexed all the statements.
Charge sheet annexed.
Charge sheet was submitted also 29/7/2007.
Both fileable.
नहीं अगले तो वारंट था कॉग्निजेंस ऑफ मिस्टेक लेते तो सही ऑर्डर टाइम
Era cognizance order.
कॉग्निजेंस
Cognizance order नहीं.
वारंट
One sequence, one to absconded. 307 Hon'Ble insertion of prayer for. এটা তো আইও প্রেয়ার করেছি
তারপর কি চার্জ শিট ଦେଇଛନ୍ତି আন্টিসিপেটেড পর্যন্ত রিজেক্ট ডিসকাশন হয়েছে ইন দি মিন টাইম দি চার্জ শিট হ্যাজ বিন সবমিটেড ইন আন্টিসিপেটেড বেল অ্যাপ্লিকেশন ইন প্যারাগ্রাফ 4 also
are the learning counsel for the petitioner and counsel for the state. The learning counsel for the petitioner submitted that earlier the petitioner approached this court in connection with this case for anticipatory bail in ABLAPL number 2680 of 2020, which was allowed by order dated 13/5/2020. However, when the charge sheet was submitted, prayer was made by the investigating officer to issue non-bailable warrant of arrest against the petitioner, and accordingly, the same was issued by virtue of which the petitioner was taken into judicial custody on କେବେ କଣ
20/11/24
20/11/2024. It is further submitted that similarly situated co-accused, namely, ସେ ଯୋଉ କାହାର ଯୋଉଟା ଯାଇଛି
କୃଷ୍ଣ ନାୟକ
ହଁ
2596
ହଁ ତା ନାଁଟା କଣ
କୃଷ୍ଣ ନାୟକ
similarly
Krishna Nayak.
situated co-accused, namely Krishna Nayak, has been directed to be released on bail by this court in BLAPL number 596 of 2017 as per order dated
7/7/17
7/7/2017, and therefore the bail application may be favorably considered. Learned counsel for the state opposed the prayer for bail mainly on the ground that the petitioner was an absconder for 7 years. And he could be apprehended only on the strength of non-bailable warrant of arrest. And once the petitioner is directed to be released on bail, there would be delay in the disposal of the trial. Considering the submission made by the learned counsel for the respective parties, the fact that the petitioner was earlier granted anticipatory bail and period of detention of the petitioner in judicial custody, and that the co-accused similarly situated has already been released on bail, I am inclined to release the petitioner on bail subject to condition that he shall appear before the Lion Trial Court on each day, which the case shall be posted, and shall not indulge in any criminal activity, violation of any terms and conditions, shall entail cancellation of bail allowed.
Problem.
Item 40.
Mr. Surya Narayan Mishra. এটা আসছি কেস ডায়েরি 500 ওর করুন তো দেখি তারা আসছি
Item 41.
May I please, my lord? I beg to appear, my lord, for virtual, my lord.
Yeah.
My lord, co-accused has already, this is the copy of the order, this flag A, my lord, as per the report, my
You
lord.
have received the case diary.
Registration order, so there is 3 criminal antecedents.
What are these offences?
FIR was lodged, my lord, 326F, my lord. That is, my lord, similar to 435, my lord. Subsequently, FIR was lodged against the unknown person, my lord. Subsequently, police added the offense, major offense 326G, that is similar to 436, and 109 IP 307, my lord. But my lord, there is no injury, my lord, and he is in custody.
What is the allegation is there?
My allegations are, my lord,
You annexed the copy of the FIR.
yes, my lord.
Yes, Hon'Ble.
Page number 11, my lord, written
ଦୁର୍ବୃତ୍ତ
FIR, my
ନିଆଁ ଲଗେଇ ତ ସ୍ଥାନରୁ କେଉଁ ଆଡେ ଚାଲି ଯାଇଛନ୍ତି?
A group of persons, they are bombing before the
ମତେ ଯେଉଁମାନେ ଫୋନରେ କରିଥିଲେ ସେମାନେ ଦିଗପହଣ୍ଡି ଫାୟାର ଷ୍ଟେସନକୁ ମଧ୍ୟ ଫୋନ କରି ଜଣାଇଥିଲେ। କାର ବାଲା ତୁରନ୍ତ ଆସି ଘଟଣାସ୍ଥଳରେ ମୋର ଗାଡିକୁ ଲିଭାଇ ଦେଲେ। ମୋର ଗାଡି ଅଟେ, ମୁଁ ଗାଡିକୁ ଚଲାଇ ମୁଁ ମୋର ଜୀବିକା ନିର୍ବାହ କରୁଛି, ତ ଗାଡିଟି ପୋଡି ନଷ୍ଟ ହୋଇଯିବା ପରେ ମୁଁ ମାନସିକ ଭାରସାମ୍ୟ ଆଣିଛି। This is against unknown persons.
yes, my lord.
As it appears the FIR. Then
Yes, ma'am.
who implicated you?
My lord, Subsequently, my lord, had improved his statement, my lord. And my lord, on the
That that very person informant implicated
yes, my lord.
in the 161.
Yes, my lord.
କଣ କହିଲା ଆପଣ ଆପଣଙ୍କୁ ଦେଖିଥିଲା ଘଟଣା ଜାଗାରେ ନା? ଆଚ୍ଛା ଗତ 8-10 ଦିନ ତଳେ ଦିଗପହଣ୍ଡିର ରାଜୁ ପାତ୍ର ନାମକ ଜଣେ ବ୍ୟକ୍ତି ଯିଏକି ଆମ ସୁଆଂଶୁ ଅଟନ୍ତି ସେ ଗାଡିକୁ ମୋ ଠାରୁ ନେଇ ତାଙ୍କ ନିଜସ୍ୱ କାମରେ ଯାଇଥିଲେ। ଆଜି ରାତିରେ କିଛି ସୁଆଂଶୁ ଆଚ୍ଛା ଘଟଣାର ସିସିଟିଭି ଫୁଟେଜରୁ ମୋର ଦୋକାନରେ ଥିବା ସିସିଟିଭି କହିଦେଇଛି ଏଇ ଘଟଣା ଯୋଗୁଁ ମୁଁ ସୁଆଂଶୁ
Page 25 also, the statement of the accused. They're saying that more now Subhendu Naik, गोटे बालनगर ब्रह्मपुर दिगपहंड को आसीलु दिगपहंड किसी काम करने आमर संतोष गौड़ बलिया से पठाई आम लोकाल छक पद्मनाभपुर पाग पहुंचा बेले पुलिस आम गोड़े आम गाड़ी छाड़ी दौड़लु गत 28/2012 समय आम दुटी गाड़ी कान्ना सेठी गाड़ी संतोष गौड़ बलिया सेठी नंदन बेहरा पप्पुलेंका राकेश साहू नील रंग बलर गाड़ी कालिया सेठी धड़ा गाड़ी कालिया सेठी जगन सेठी चंदन महांती कान्ना सेठी और मो दिगपहंड जाई नुआ मौलभजा छक धड़ा रंग महिंद्रा XU5 गाड़ी को पोड़ी जलाई देवाई जाइए प्रथम जाए से गाड़ी चलवा ड्राइवर घर माड़ करी चली आसी रखि गाड़ी आम सहित बलिया सेठी राकेश साहू पेट्रोल ढाड़ी निआ लगे से गाड़ी मानक रायगड़ा जा रास्ते पलैली बाटर आम पुलिस पेट्रोलिंग गाड़ी भेटी मात्र आम जोरे पलि आसिलु यही काम करने
who has got criminal antecedent as it appears from the rejection order. Petition number 3 means Chandan Kumar Sahi.
The present accused has one criminal antecedent, my lord, but not similar, my lord, and he has already reached on bail, my lord.
Who are in custody since
4th November 2024, my lord. 4th November, my lord.
Are the Land Council for the petitioner and counsel for the case, considering the submission made by the Land Council for the petition, that the petitioner is in judicial custody since 4/11/2024, and the first information report was lodged against unknown persons, and thereafter the petitioners have been falsely entangled in the case, and the ingredients of the offense. What is the 436 BNS
326
326G
326G
326F
326F. FIR was lodged in 326F. That was 435, similar to IPC, and my lord 326G is the similar to 436.
The ingredients of the offense under section 326G of BNS are not attracted, and after hearing the Land Council for the state who submitted that the petitioner has got one criminal antecedent,
Yes, ma'am.
I am inclined to release the petitioner on bail, subject to condition that he shall not indulge in any criminal activity and appear before the IAC of the Gopandi police station once in a, your house is at a different place. Okay. All right. No, not indulge in any criminal activities, violation of any terms and conditions, shall entail cancellation of bail allowed. Yes.
Item 42.
Please, your
Item 40. 40 টা 500 করে দিলাম ଅଛି না কেস one week after my you want adjournment acha learning counsel for the 40 relative submits that he has received the case diary. The learning counsel for the petitioner seeks for an adjournment. Please this matter you want 1 week after. All right, please this matter in the week commencing from 20th of January 2025. Yeah.
Item 42.
Please, my lord.
42 is my lord, page 2, she is not available.
Case diary not available. All right, the Land Council for the state seeks some time to obtain the case diary, criminal antecedent. Put up this matter in the week commencing from 20th of January 2025. Yes.
May I pray one thing, my lords?
Yes, Mr. Panda.
Can the status report be called for also?
Status report be called for. File be placed before the land and registered judicial. Yes, next.
Item 43.
43, your lordship, may kindly say page 57.
43, you have got the case diary.
No, madam, she did not.
57 में कौन होला?
See, your lordship, may kindly see 57, this application was rejected. And if your lordship wants to hear this matter, I don't have any objection, but this is my duty to draw your lordship kindly.
No, but if I have rejected it earlier in respect of any court,
Yes, in 2021.
then I have to, because the
Yes.
first application.
Yes, and your lordship, may kindly see, I have annexed everything in order to draw your lordship.
No, your bail application, you said that it was rejected earlier.
Yes.
And it was, what is the quantity here?
105 kg.
So,
105 kg, that was not seized from my conscious possession. It is seized from the house of one Pradeep Das, whose bail application lordship has rejected.
all these contentions have been taken into account, and on merit it has been rejected. So what is the
No,
development?
on merit it has not been rejected. On the ground of a criminal antecedent, my application was rejected. And you lordship may kindly see, I have given all the deposition copy. In the meantime, I am in custody since lordship may kindly see the date. I am in custody on 21/9/2022. Lordship got it.
You have got the
Local
case
custody.
Evidence.
Yeah, I have given all evidence of
Yes,
all
file the
independent witnesses have gone hostile.
Just
Mine.
Yes, file the evidence copy, but she did not do it.
all right. The Land and Council for the state should sometime produce the case diary. The Land Council for the petitioner submitted that the petitioner is in judicial custody since Kevedo
21/9/2022 on the direction of on this on the report.
2022. And how many witnesses have been examined?
In the meantime, my lord, out of 30,
There 19 witnesses.
19 witnesses examined out of 34 witnesses. All 19 witnesses have not supported the prosecution case, not whispered a single word against me.
Out of 34 charge sheet witnesses, 19 witnesses have been examined. Status report be called from the Land and Trial Court. Matter be registered in the re-summation from 20th of January 2025. Case diary as well as criminal antecedent to be obtained. Yes.
Item 44.
May I please, your lordship, I am placing Milord on behalf of my Lord son S.R. Rao, Pure Milord 109, IPC 307, simple injury, my lord granted bail in respect of other co-accused persons. That is, and moreover, this is a dispute, Milord, regarding Kartik Seswara Bhasan, Milord. I am giving the order, Milord, my lord will take everything. Therein also informant appear. Simple injury.
Case and counter case and the occurrence in question took place during the immersion ceremony of goddess, a god Kartik Seswara.
Yes.
And there are 3 injured persons, mainly so and so. First one, the bruise in the eye, and it is opined to be simple in nature. And one Kiran Behra who has sustained head injury, which has been opined to be grievous and not. And Kiran has been discharged from the hospital. Yes, and his wife Helen Rafiq also. Yes, he keep it well and
Custody Milord same. Custody 3/12/2024.
considering the submission made by the Land and Council for the petitioners, that the petitioner is in judicial custody since 3/12/2023. बाकी यहाँ अच्छी है too, and it is a case and counter case and so on so on so up to mayor civil informant for them. ना ये जो एक अगर informant की appear करना चाहिए ये line तो exclude करिए है ना and 80 जो ताका submission पर आखिर जोड़ी देवे and that similarly situated co-accused persons have been directed to be released on bail in BLAPL number 12850 of 2024 as per order dated 24/12/2024. Copy of which is filed and taken on record And after hearing the land council for the state, I am inclined to swan. But the terms and conditions they are the same way. No blame.
Item 45.
Yes.
May I prevail? Notice may be
Item 46.
My lord, on behalf of Mr. Sahoo, kindly take the next step. I'm appealing for the information.
46 रे informant ପାଇଁ ଆପଣ appeal କରୁଛନ୍ତି?
My lord,
Name is there already.
I'm appealing on behalf of Mr. Mahesh Das.
ହଁ ଠିକ ଅଛି. What do you want?
Adjournment, my lord.
Adjournment. You have received the case diary? All right. The Learned Counsel for the state submits that he has received the case diary. Learned Counsel for the informant is present. A mention is made on behalf of the Learned Counsel for the petitioner for adjournment. Please this matter week commencing from 20th of January 2025. Hello? Next.
Item 47.
Item 47 and 48, 302, 3 SCST. No case diary, notice also required.
Notice जाएंगी?
Yes.
अच्छा एक्स्ट्रा कॉपी लग देवे है ना? यूजुअल ऑर्डर कर देवे CD CA 20 तारीख January 2025. Yes, next.
That's in the meantime, call for the status.
अच्छा status report ही मोगी लेंगे ना? File be placed before. अच्छा liquidation one of the offenses under SCSTR. Yes, next.
All right.
Item 49.
May I please?
So, under section 341, 324, 326, 307, 440, 34, read with 3 SCST Act law. So, it is the second and before Lord says.
Your bail application, earlier bail application was rejected.
That is with a liberty to renew the prayer after charge.
Just a minute.
Relevant question, my lord, 31.
31. After looking at photographs and statement of the victim, so also the injury report and considering the submission made by the Land Council for the respective parties, I am not inclined. कौन photographs रे असले लगी?
I put the informant will.
कौन असला photograph?
The mouth has been operated.
কথা কই পান
After paper, one of two hands.
कौन 307
पेट्रोल पके की नहीं
petrol पकी?
Both the hand flashing surgery to be done.
कौन देखा ही मैंने कौन थी वो ना photograph रे?
and the deposition of the father of the
अच्छा वो वो देखती है. हाँ कौन है ना ये?
What happened? Petition is in custody.
हाँ हेला जे तापर कौन है ना किसी आला नंबर लानी?
ବର୍ତ୍ତମାନ sir, out of 29 witnesses, 19 witnesses have been already
यानी
absent.
से लोग से पिला इसे
That fella intentionally asunanti, but EW1 is the only witnesses. She stated kindly see.
victim examine हो तकवानी produce करो. Next date के बाद
Straight exactly जानेंगे. We are.
दिन तू हमें बुलिंग करो.
no jana examination.
No, we are concerned with the examination of the NGO.
What happened, my lord? And PW wanted to
He
he is the self only witnesses.
Your examination. The Learned Counsel for the petitioner submitted that in the meantime, earlier when the petitioner approached this court in CRLA number 1222 of 2023, which was rejected as per the order dated 19/3/2024, and the petitioner was given liberty to renew the prayer for bail after the charge is framed. Land Council submits that in the meantime, trial has commenced and 9 witnesses have been examined.
Deposition
19. Out of 29, 19 witnesses.
Deposition they not done.
Now,
19 witnesses have been examined. Stop. However, in spite of repeated issuance of summons, the injured is not appearing to give the evidence, right? And now the case is posted to dash. ମୁଁ gap ରଖି ଦଉଛି ଆପଣ ଆଣିକିନି court master କୁ ଦେବେ ହେଲା. The Learned Counsel for the state submitted that the Learned Counsel for the petitioner has supplied him the deposition copies of only 9 witnesses. Let the Learned Counsel for the petitioner supply the deposition copies of the rest of the witnesses to the Learned Counsel for the state. Put up this matter, say you a date yesterday. Let the IIC of Uthana, Tomka police station appear before the Learned trial court. That date receive summons in respect of the injured and ensure his attendance on the date fixed. तार गोटे सप्ताह पर रखिबे तारीख को the land and council for the petitioner shall produce the certified copy of the deposition of the injured on the next date, serving copy on the land and council for the so and so. The land and council for the informant has also stated that he shall pass necessary instruction to the informant to ensure the attendance of the injured on the date fixed. ହେଲା ଆପଣ ଆପଣ କ୍ଲାଏଣ୍ଟ କହିବେ ସେ ଡେଟ୍ ଦେବେ ଆଇଆଇସି ଆଣିକିନି ଥାନାରେ ସମନ୍ସ ଆଣିକିନି ସର୍ଭ କରି ନେଇ ପହଞ୍ଚେଇବେ
What happens, my lord? If the party to plastic surgery, but then see now he.
କୋର୍ଟ ଦେଖିକି ଲେଖିଦେବେ ଯେ ବର୍ତ୍ତମାନ ସେ ତାର ଅବସ୍ଥା ଏଇ ଟାଇପ ର ଏଭିଡେନ୍ସ ରେକର୍ଡ କରିବା ସମ୍ଭବ ନୁହେଁ ବା ଯାହା ବି ହଉ ତେଣୁ ଆପଣ କୋର୍ଟରେ ପ୍ରଡ୍ୟୁସ କରିଦିଅନ୍ତୁ ବାରମ୍ବାର ନ ପ୍ରଡ୍ୟୁସ କରିବାଟା ଠିକ ନୁହେଁ ତାର ଲିବର୍ଟି ଏଫେକ୍ଟେଡ ହଉଛି ଅଲ୍ଟିମେଟଲି କନଭିକ୍ସନ ହବ କଣ ହବ ଦ୍ୟାଟ୍ସ ଏ ଡିଫରେଣ୍ଟ ମ୍ୟାଟର ହେଲା ୟେସ୍ ଗିଭ୍ ଦି ଡେଟ୍
ମତେ ବି ଟିକେ ଦେବେ ମୁଁ ଆଇଆଇସି ଜାଣିବି
as a free copy of the order be handed over to the land and council for these two.
Item 50.
May I please your
नौ तारीख तो
नेक्स्ट डेट था
appear करू 6 तारीख दिन आज ଦେଇଦେବି ଆପଣଙ୍କୁ କୋଉ ଥାନା ଆଇଆଇସି
ସୁଖିନ
ହଁ ତ
ଟମକା
date is fixed to 9th so he will appear before the land and trial court on 6th receive summons and ensure the attendance of the sworn judge matter be listed in the week commencing from 20th बाकी तो रहेगा है ना
Pardon, my lord. Item 21, 27, when it was called, I was not present. my lord.
Just a minute. हाँ, कौन है ना?
Item 27, when it was called, I was
कितने
not
नंबर
7.
27 पर हम अलाउ कर देगी रिजेक्ट कर देगी
नहीं रो oblige.
अच्छा এটা ଆଉ ଗୋଟେ ମ୍ୟାଟର ରହିଛି
Time